Judgment in the matter of Frenkel against La Micro Group Limited and others, and La Micro Group Inc. against La Micro Group UK Limited and others.
This appeal is about a well-known creature of equity called the Vendor-Purchaser Constructive Trust. I will call it the VPCT for short. It arises where a vendor agrees to sell property to a purchaser, and the property is of such a kind that, if the vendor refused then to transfer the property, the court would order him to do so, rather than merely award the purchaser damages for breach of contract. From the moment of the agreement, equity treats the vendor as holding the property on trust for the purchaser. The vendor must not sell it to someone else or damage it. If the purchaser pays the purchase price, then the vendor holds it on bare trust for the purchaser until he transfers legal title to the purchaser. In other words, having received the price, the vendor must then treat the purchaser as the beneficial owner of the property, even though the vendor retains the legal title to it. This type of constructive trust is the practicable application of the principle that equity treats as done that which ought to be done. The typical property to which a VPCT attaches is land, but it also attaches to shares in a private company. In the present case, the subject matter of the sale was a 51% equitable interest in each of the only 2 issued shares in a private company called La Micro UK. I'll call it UK for short. The VPCT also generally attaches to an equitable interest in a share in a private company. The critical issue of law in the present case is this. Granted that a VPCT would arise on the sale of such an equitable interest in a share to anyone else in the world, does it arise where the purchaser is at the same time of the sale both the holder of the legal title to the share and also the owner of the remainder of the equitable interest in it? One might ask, why not? But the appellant says that in such a case, because all the equitable interests in the share merge and disappear in the legal title once owned by the same person, an agreement for sale of such an equitable interest to the holder of the legal title is really just an agreement for the surrender or destruction of the vendor's equitable interest, so that there is no property, the subject matter of the sale, to which any constructive trust can or should attach. It's one thing, they say, to hold on trust some property which you have agreed to sell to someone else, but quite another, and conceptually wrong, to hold on trust something which you have merely agreed to have destroyed. This apparently abstract question really matters. If there is no constructive trust, a purely oral agreement for the disposition of an equitable interest is ineffective, because such a disposition must be in writing under Section 53(1)(c) of the Law of Property Act 1925. And disposition is defined in the Act as including a mere release for destruction. But if there is a constructive trust, then it operates without the need for any writing under Section 53(2) of the Act. Furthermore, a VPCT in such a case, where the subject matter of the trust is only an equitable interest, is immediately effective to confer upon the purchaser the subject matter of the sale, i.e. the beneficial interest in the property, once the purchase money is paid. The relevant facts as found by the trial judge may be summarized as follows. Mr. Lyampert set up a company called La Micro Inc., I'll call it Inc., in California in 2001 as a trader in computer hardware. Mr. Frenkel joined him in the business, and they became 50-50 owners of Inc. Mr. Bell traded in computer hardware in the UK through a company called B-Stock Limited. B-Stock and Inc. began trading with each other. Eventually, Mr. Lyampert, Mr. Frenkel, and Mr. Bell decided to embark upon a joint business venture, trading in computer hardware in both the USA and the UK. For that purpose, they set up La Micro UK Limited, or UK. UK originally had only one share issued to Mr. Bell, which he held on trust for himself as to 49% and for Inc. as to 51%. Later, a second share was issued to Mr. Lyampert, which he held on trust for Mr. Bell as to 49% and for Inc. as to 51%. So Inc. became the 51% beneficial owner of UK through its 2 issued shares. In 2010, Mr. Lyampert and Mr. Frenkel fell out. Mr. Frenkel told Mr. Bell that he wanted nothing further to do with UK or its business. Later, in 2010, Mr. Bell and Mr. Lyampert made an oral agreement, both for themselves and for Inc. and UK, and I'll call it the 2010 agreement, under which the two individuals would thereafter split the profits of UK on a 50-50 basis, and Inc. would be paid for its interest in UK by Mr. Lyampert becoming immediately liable for Inc.'s by then large debt to UK. The judge found that there was an implied term in the 2010 agreement that Inc. would transfer its 51% beneficial interest in each of UK's two shares to Mr. Bell and Mr. Lyampert, who already held the legal title to each of them, and Mr. Bell would transfer to Mr. Lyampert his 49% interest in the share of which Mr. Lyampert was the legal owner. This would leave each of Mr. Bell and Mr. Lyampert as the sole beneficial owner of the share to which they held the legal title, so that they became the 50-50 beneficial owners of UK. UK's business prospered, and Mr. Frenkel eventually repented of his decision to have nothing further to do with it. So he arranged for Inc. to assert that its original 51% interest in UK had never been agreed to be transferred, still less validly transferred, to Mr. Lyampert and Mr. Bell. After complex litigation, including 2 trials and 2 visits to the Court of Appeal, the sole basis upon which Inc.'s claim still to be the 51% owner of UK was finally rejected by the Court of Appeal was that the 2010 agreement, coupled with the payment of the price for Inc.'s equitable interest in each of UK's shares, was sufficient to give rise to a constructive trust of that interest in favour of Mr. Bell and Mr. Lyampert, even if only momentarily, so that they each thereby became, by the merger of all the relevant equitable interests in their legal title to each share, the respective outright beneficial owners of the shares. Inc. appealed to this court, putting forward the argument about the destruction of the relevant equitable interests of Inc. in each share, which I have already described. This court unanimously upholds the Court of Appeal's conclusion. I give the only judgment with which Lord Hodge, Lord Sales, Lord Burrows and Lord Richards agree. Our reasons are, in summary, as follows. A. Leaving aside the technical equitable mechanics, the substance of the transaction, viewed from the business perspective of the parties, was the transfer from Inc. to Mr. Bell and Mr. Lyampert, respectively, of Inc.'s 51% beneficial interest in each of the 2 issued shares in UK. It wasn't an agreement for the destruction of anything. B. Even if looked at from a technical perspective, the destruction of Inc.'s equitable interest in each of the 2 shares only came about by merger once it arrived in the same hands as the holder of the legal title. There needed to be a transfer of that equitable interest to Mr. Bell and to Mr. Lyampert for that destruction by merger to take place. Even if the constructive trust which arose from the 2010 agreement and the immediate payment of the price lasted only for a moment, that was both necessary and sufficient for merger of the equitable interest in the legal title to take place. The fact that the constructive trust only had a momentary life was no obstacle to its existence. C. The appellant's destruction argument would produce irrational and arbitrary results. It depends upon the mere happenstance that the purchasers of Inc.'s equitable interest each held the legal title to their share in UK. It would not occur, even on the appellant's argument, if the legal title to the 2 shares had been reversed, or if the agreement by Mr. Bell to transfer his 49% interest in the second share to Mr. Lyampert had followed, rather than preceded or accompanied Inc.'s agreement to transfer its 51% interest, even by only 5 minutes. None of these strange results flow from the Court of Appeal's analysis, which suggests that it is to be preferred. As an added argument, the respondents sought permission to argue that Section 53(1)(c) only applies to equitable interests in land. While that might have been arguable in 1925, as a matter of construing the language of the Act when it was passed, it has for so long been held and understood that Section 53(1)(c) applies to all equitable interests that it is much too late, nearly a century later, to change the course of legal history. For that reason, we refuse permission. Nonetheless, for the reasons already given, the appeal is dismissed. Court is now adjourned.